Sego, sewa gwego. Hope everybody's doing okay. I wanted to touch a little subject on this capsule today on the issue of the land claim, the specific claim that Kanesatake has been in since 2011. A little brief history on that is back in 1977, the claim was put in front of the government, and later on there have been some arguments back and forth up to 1984. You see, Kanesatake had submitted its claim not under specific, it was under a third kind. This position remained firm right up till 1990. After 1990, the government felt they needed to deal with this issue and needed to deal with it quick for good reasons. But then again, they kept promoting their specific claim, even though an agenda and process for negotiations, protocol was established with the council at the time. So ever since then, the arguments have remained pretty stable. When we talk about our ancestors being here, the reasons why the seigneurie was created. Now, some people may understand or remember some of our stories that basically the French crown at the time wanted to move us away from Montreal, which is called Jujake. And they wanted to move us away because it was to get us away from the evils of alcohol near Montreal. So they created this seigneurie over here, saying they were going to move us here. But they knew well that these were our old hunting grounds, our old settlements, and we were just reestablishing where we used to be, or still were at the time. So that did not give the Sulpicians the right to take the lands for themselves. And we've made good arguments at the tables for that. In 1717, it's argued now that the French crown created a trust. And I brought this argument before, that under trust law, the trustee may not enrich themselves with the benefits of the beneficiary, beneficiaries being us. So holding the lands for our benefit to make sure that we live peaceably on this land and, just enjoy the benefits. Now, over the years, that's not what happened. We all know that. Over 98% of our territory that was promised under treaty was taken from us. And we've derived absolutely no benefits or very little of the benefits of the land since then. We've presented arguments at the claim. One is that, again, we are not supposed to be in a specific claim, but we had to go along with it because the risk of having Canada close the book on us was too great. So we figured we'll make do with what we have at hand. Keep Canada at the table, keep talking, and it's a good thing we did. Because during these 9.5 years, changes have happened. The latest one was the Chilcotin decision from the Supreme Court, which for the first time, a court has made a decision or rendered an opinion on Aboriginal title that it is there and it works this way. So that changed a lot. Then the UN came up with the UN Declaration on Indigenous Rights, and there have been other changes. We won't start talking about them all, but we had a good position, and it just got better. At the claim, we presented our history, our reasoning behind it, why the Sulpicians did not own the land. Because under French law, had they owned the land, it would have been under the title of franc alleux noble or franc alleux routurier, under French law. And that wasn't done. So obviously there was something else. Even the Privy Council of 1912, when their decision in the Corinth case, said it was obvious that we were dealing with some form of trust and that all parties should go to the proper judicial processes in this country and settle the matter. That was never done. So we presented our historical legal arguments to the feds at the table. One of the points that we discussed was the size of the small commons that we were in negotiation for. Of course, well, the federal government said it was only this much, and we said it was this much. And in the end, we pretty much got all of what we were saying was the small commons. Okay, there were some small exceptions that we didn't agree with, but we managed to keep that part of the claim open later on for the acres that they wouldn't recognize. So as we were talking, we started looking at, okay, the monetary compensation. What is it worth? They were using the word loss of use, where I don't like the word loss, because loss implies that it's gone. And we never agreed that it's gone, and it's still there. It's just that we were denied the use. So we're going to move on with that one. And the financial compensation is based on that. So what was it worth? What would we have done with the lands had we retained a continued occupation? And we came up with a certain number. We said, no way, it's impossible. It can't be that low. So we conducted another study from a gentleman, Dr. Carl Beal. Carl Beal helped us look at the size of the commons and compare it to other claims, compare it to other regions that were similar to ours, and came up with a much higher number. Now, specific claims only goes to 150 million, but there's really no limitations on Canada on going ahead, bringing it to cabinet, and agreeing to a higher amount. So there's a lot of things that play here. There was also canon law. We were supposed to do a study on that because the Sulpicians under canon law would not have had the right to own anything under that law. We brought all kinds of arguments at the table. And the idea of trust law also came up. This was not readily welcome, but brought it up to the table nonetheless. Now, in addition to a lot of our arguments, there was some talk about acquired rights, that the third parties that are on the lands right now may have had an acquired right. Well, in my opinion, I think you would agree. An acquired right is if you take something and no one says anything about it. You don't protest it. You don't take any form of action. Well, in our case here, we've been saying it for 300 years. So there's nothing acquired. Not in the least. Our arguments have been consistent, and our protests have been just as consistent about the taking of our lands. So I think we could take the acquired right off the table. So there were years where we had one negotiation, like there was 1 year we had absolutely no negotiation at all. Because quite honestly, we felt that we were just not working in the right direction, and that we needed to get some political commitments, which I got. The federal government is more than open now to the concessions that we've been looking for. And I hate to say it, but I was informed that a copy of the release was leaked by a chief on council to a band member who may very well sabotage the entire claim. Because the document that was shared is a draft. It's something that needed to be reworked. And doing something like this just it's not going to help. It's not going to help our position. So I'm looking at different options with Minister Bennett and various departments. It's not just the compensation. It's the terms of the compensation that we don't agree with. It's the acquisition of lands. Who's responsible? It's the municipality. Why would I need to go to the municipality to repatriate lands? Anyways, we had a lot of arguments on that. So there are things there that we still need to work out, like the in lieu of taxes. How do we develop the lands? How do we protect the lands? There's so much that goes with this. And when it comes to the specific claim and the release that was offered, we're far from done. We still need to bring this back to the community for in-depth consultation on what's on the table. How is it going to be worked? It took us 9.5 years, but the work is not done. Now, I also made it clear to Mr. Hutchins, our legal, that the release should be without prejudice to any of the Haudenosaunee or those that identify as Haudenosaunee and their positions. I feel myself, as a band member here, the community deserves to be compensated, but not at the expense of our Aboriginal title. Never. We've suffered a huge historical wrong. I think, in my humble opinion, the biggest theft that's ever happened. And I want to make sure that everything is done the right way. And it takes time. It takes a lot of effort, a lot of reading and learning. So I think we've done pretty good, and we're still fighting, and we're not going to give it up. Despite what people say, like last summer, one was he said that if we get this compensation, there'll be nothing left for our band members, for our community, because all the money's going to go to the lawyers, which is absolutely false. The lawyers are all covered, so whatever compensation comes in will be fully to the community. So if we can just continue on with respectful dialogue and common sense, I think we can solve this thing a lot quicker and for the benefit of everyone. So I thank you for your time. Now go on.